Good morning. It is February 27th, 2023, roughly 9:30 a.m. on the East Coast. Every opportunity. Likewise, among those who are believers and make the most of every opportunity, let your conversations be gracious and attractive so that you will have the right response for everyone. Colossians 4 5 through 6. Who are the people around you who need God? Take a deep breath, close your eyes, and consider those who are close to you that, for one reason or another, are not following God. Is there someone in your family, perhaps one of your friends, a coworker, a neighbor, having the right response for someone is not really about knowing how to win an argument. It's much more about living in such a way through the circumstances of life that others take notice. You want others to see a wellspring of strength and a daily resource in you. You want them to think there's something different about him. He has peace that I need. When that moment comes, you'll want to be ready to share about the source of your strength and courage. It is in the everyday moments that your life has its greatest impact. How others see you in those routines, accidents, stress, and relationships will reveal to them who you truly are and what you truly have. How you live in your everyday life could make the difference between someone finding God or continuing to live apart from him. God, let me live consistently in your patterns every day so I may be ready to share at any moment how great you are. Today, we're going to start out this morning by graciously thanking a good friend and a brother of mine for quite a many of years, Mark Metz, who was very elated last night to get this information to me. And he's like, you got to share it with people there. You got a platform, and these people need to hear this information. And Mark has consecutively, time and time again, just nailed grand slams clean out of the park. He is really good at what he does. He likes the simple, short, Socratic method. He doesn't like to piss around, I guess you could say. He just wants to get in there, put the dagger in the dragon's heart, and walk the fuck out. And he is very efficient at it. He doesn't ever take on things that he can't handle, and that's one of the things I admire about Mark Metz. You know, if you tell him your situation and he says, look, I'm just too busy, or that's a little more complicated than I like to deal with, he is giving you an honest shake. So with that, just like to extend a bit of gratitude to Mark Metz. Thanks again for thinking of me and the rest of us and sharing this information with me yesterday evening. Removing liens and levies by suing IRS for disclosing confidential information. Larry Backman, March 24th, 2003. In the January 14th, 2003 edition of Tax Truth newsletter, we told our readers that American Rights Litigators, ARL, would likely be working with Richard Standring's organization. VIP, that's because they have been effective in getting IRS liens and levy notices removed. Eddie Kahn told us this week about a particular strategy used by VIP that many of our readers will find interesting. According to Mr. Stadring, whenever the IRS sends out a notice of lien or levy, they violate privacy laws by giving out unauthorized tax information to the public. For example, when the IRS files a notice of federal tax lien in the county recorder's office, anybody in the world can go look at it, right? They could see everything on that notice, including your name, social security number, and the dollar amounts of what the IRS claims you owe, etc. However, according to Title 26, which, mind you, is the IRS's own code, Title 26 USC subsection 6103, which is what they're bound by, along with the Internal Revenue Service Manual, the IRM. According to Title 26 USC subsection 6103, it says that the IRS cannot disclose confidential information to public unless they have your permission. Now, this is where Mark's going to want to kick me in the nuts because it's also in Title 15, ladies and gentlemen. And like Mark said, most people can't do what we do, so don't expand on it too much and give them so much ammunition that they think they've got to use it all. But I do want to inform you that Title 15 is very clear. If you haven't given express written consent for them to have permissible purpose to share your information in written form, ladies and gentlemen, you have a claim for identity theft under Title 18, 1021A. And that's aggravated identity theft. All right. And you have a Hobbs Act violation. You have a breach of trust. You have invasion of privacy. There's a number of other things that can go on that: slander, defamation of character, extortion, so on and so forth. But to keep it simple, according to Title 26 USC subsection 6103, it says that the IRS cannot disclose confidential information to the public unless they have permission from you, which means expressed written consent. It can't just be oral, it needs to be written form. All right. Therefore, Eddie looked in the procedural regulations under Title 26 CFR subsection 301.6103 that relate to section 6103 of the tax code. He found some very interesting reading there talking about how the IRS must have your written permission before they can disclose anything. For example, one provision says generally information of a confidential nature can only be disclosed upon a taxpayer's written authorization. Internal Revenue Manual 1272 Disclosure of Official Information Handbook contains instructions relating to disclosure matters. Even the IRS, folks, Criminal Handbook talks about the same thing. According to Eddie, the IRS must have your permission. That's right, express written consent. It says that the agency cannot disclose a person's confidential information to any third party unless that person completes a Form 2848, which is power of attorney, or Form 8821 for reference. Form 2848 is the IRS power of attorney form and declaration of representative form. Form 8821, entitled Tax Information Authorization, is the IRS designated form for a person to authorize disclosure of their confidential information. Based upon this knowledge, Mr. Standring told Eddie that VIP strategy is to do some sort of administrative action whenever the IRS issues a notice of lien or levy. They declared that the IRS is in violation of Section 6103 of the tax code. At first, Eddie thought it was a lawsuit that VIP filed, but he learned later from Mr. Standring that the strategy is administrative in nature. However, there is a court case in Florida where this was an issue. A doctor sued the U.S. for unauthorized disclosure of information to his clients by an IRS Criminal Investigation Division CID agent. The man, Dr. Reedy, won the case. Evidently, it was rather simple as there wasn't much to the lawsuit. Remember, keep it simple, stupid, and you can win every time. Make sure the scope is narrow and your point is poignant, and stick with it. Don't leave the scope of the suit. Make it simple, short, sweet, and concise. According to Eddie, the only thing the IRS disclosed when questioning his client was his name, identification number, and that Dr. Reed was under investigation. Furthermore, they included a return envelope addressed to the CID in West Palm Beach, Florida. That was enough to cause a violation of Section 6103. When you look at the definition of return information, investigations and taxpayer identity are included as things the IRS cannot disclose. Yet they did with Mr. Dr. Reedy. The CID asked Dr. Reed's, I don't know if it's Reed's or Reedy's, client questions, of course, but that's not unauthorized disclosure. The unauthorized disclosure happened when they gave information to his clients. What made this case interesting, though, was that after that Dr. Reedy's attorney filed the complaint, the U.S. attorney immediately capitulated. He admitted that the IRS did what the IRS did was wrong. Without any resistance, Dr. Reedy didn't have to fight for it at all. Then the U.S. attorney put in a Rule 68 or 69 saying that the IRS was willing to settle for $1,000 per 126 clients involved, because it's $1,000 per violation. That's also found in the Fair Debt Collection Practices Act in Title 15. That would be Title 15, 1692. All right. Plus court costs and attorney's fees. That's all there was to it. ARL has a complete copy of this case, U.S. versus Reedy or Reed, available on a CD for $20, including shipping. If you would like to have a copy of it, then please send your payment to American Rights Litigators, 25525 State Road 46, Mount Plymouth, Florida, 32776. Eddie said he couldn't see why suing the IRS for disclosing information and a notice of lien and levy wouldn't do as well as the Reedy case. It seems that it would make for an even stronger case than what the doctor had. That's because the IRS always shows your name, ID number, alleged date of assessment, how much you supposedly owe, interest and penalties, etc. They show everything. All of that is tax return information that you never authorized them to disclose. Therefore, Eddie figures that if the IRS puts that information in the county records, then potentially everybody could see it. If there are 1 million people in the county, then that could mean an awful lot of money to you at $1,000 per person per violation. You could always claim that everybody in the county potentially could see it. In reality, it's much more than that, though, because if the county records are online, that means everybody in the world could see it. Population estimated about 7 billion. If you're going based upon just the population of the United States per the census, it's well over 350 million, plus about 50 million, give or take, illegal immigrants. So there's, 400 million times 1,000. However, limiting your claim to just the county would keep things within some bounds of reason. Nevertheless, Eddie thinks that it's always BAT to do administrative procedures first to seek a remedy. Always best, typo, to do administrative procedures first to seek a remedy, such as Mr. Standring's administrative strategy. Then, if the IRS doesn't respond, you do a notarial protest to get an administrative judgment from the notary. If they still won't budge after that, then you could go into court where you will have an even stronger position at that point. Your judicial judgment against the IRS will be just a matter of form, because you will already have a notary's administrative judgment. If you go into court though, and the IRS doesn't respond to the charge, then you will get a default judgment against them. Let's think about this for a moment. If the IRS filed a notice of lien on you in the county recorder's office and you get a default judgment, then what would happen to that notice of lien? It would have to disappear from the county records. The county recorder would have to remove it because the default judgment would show that there was no basis for the IRS to disclose your confidential information. Therefore, the IRS had no authority to make that information available to the public since there was no court action. If there was court action involved, however, then all of your information could and would be public record, yet they didn't. So, there is nothing that gives the IRS the right to disclose your private information without your consent. Eddie thinks this idea of the IRS violating Section 6103 is a very clever way of attacking the IRS notice of lien. The argument has nothing to do with taxes or whether you owe the IRS any money at all. It's all about procedure. The only issue in question is that you didn't give the IRS the required written authorization to release your private information to the public, even when the IRS sends out a notice of levy on someone. Who do they send it to? They send it to a person's employer or bank, which is the public. Yet, the public doesn't have a right to see your confidential information contained on it without a court action being initiated. Actually, the IRS is supposed to have a court order judgment before they can ever seize a person's property via a notice of levy. And that's in the IRS Enforcement Agency Handbook as well. They talk about the Fourth Amendment, Fifth Amendment, the Sixth Amendment, and not collecting any information or data or disseminating any information or data that would violate the rights of the purported taxpayer. Here's another nice thing about getting a default judgment against the IRS. Do you think the IRS will ever try to impose another notice of lien or levy on you for the same tax year or other tax years? Probably not. They probably wouldn't, because if they ever did, then they would be in contempt of court. When you knock out the lien and levy, the IRS has nothing to go on civilly. That applies to state revenue authorities too, as they all piggyback off the IRS. The bottom line is, there are two ways in which you can go after the IRS when they disclose your confidential information without your consent. You can go after them civilly and or criminally. Title 26 U.S.C. subsection 7431 shows us that the IRS is subject to civil penalties if they disclose your confidential information without your consent. The criminal penalties are listed under Title 26 U.S.C. subsection 7213 and Title 18 U.S.C. 1905. Then, when you look at the Privacy Act, it also says that you can go after them civilly and criminally. The criminal penalty is a misdemeanor count and a $5,000 fine for each offense. Therefore, there is nothing that we know of that would prevent a person from pursuing the IRS. I hate spelling errors. Back civilly or criminally. Eddie likes this because it gives you a double shot at them. Title 26 Internal Revenue Code, Title F, Procedures and Administration, Chapter 61, Information and Return, Subchapter B, Miscellaneous Provisions, Section 6103, Confidentiality and Disclosure of Returns and Return Information. A. General. Returns and return information shall be confidential. There it is, right there in 6103. All right. 2. No officer or employee of any state, any local child support enforcement agency, or any local agency administering a program listed in subsection I-7D or 17D, I think it's I-7D, who has or had access to returns or return information under this section. And 3, no other person or officers or employees thereof who has or had access to the returns or return information under subsection E1D3, paragraph 6, 12, or 16 of section I, paragraph 2 or 4B of subsection M, or subsection N shall disclose any return. We love that word, any or. Or is an audible. Any means everything. Any and all. We love those. Return or return information obtained by him in any manner at all, in connection with his service as such an officer or an employee, or otherwise, or under the provisions of this section for purposes of this subsection. The term officer or employee includes a former officer or employee. B. Definitions. For the purposes of this section, 1. Return. The term return means any tax or information return, declaration of estimated tax, or claim for refund required by or provided for or permitted under the and except as authorized by this title. 1. No officer or employee of the United States provisions of this title which is filed with the Secretary by, on behalf of, or with respect to any person, and any amendment or supplement thereto, including supporting schedules, attachments, or list which are supplemental to or part of the return so filed. 2. Return information. The term return information, or the return of information, means a taxpayer's identity, the nature, source, or amount of his income, payments, receipts, deductions, exemptions, credits, assets, liabilities, net worth, tax liability, tax withheld, deficiencies, over assessments, or tax payments. Whether the taxpayer returns was, is, being, or will be examined or subject to other investigations or proceedings or processing, or any other data received by, recorded by, prepared by, furnished to, or collected by the Secretary with respect to a return or with respect to the determination of the existence or possible existence of liability or the amount thereof of any person under this title for any tax, penalty, interest, fine, forfeiture, or other imposition or offense. Title 26 Internal Revenue Code, Subtitle F, Procedures and Administration, Chapter 76, Judicial Proceedings, Subchapter B, Proceedings by Taxpayers and Third Parties, Sections 7431. Civil damages for unauthorized inspection or disclosure of return and return information. A. In general, 1. Inspections or disclosure by employee of the United States of any officer or employee of the United States knowingly or by reason of negligence inspects or discloses any return or return information with respect to a taxpayer in violation of any provision of Section 6103. Such taxpayer may bring a civil action for damages against the United States in a district court of the United States. C. Damages. In any action brought under subsection A upon a finding of a liability on the part of the defendant shall be liable to the plaintiff in an amount equal to the sum of 1. The greater of A. 1,000 for each act of unauthorized inspections or disclosures of a return or return information with respect to which such defendant is found liable, or B. The sum of B1. The actual damages sustained by the plaintiff as a result of such unauthorized inspections or disclosures, plus 2. In the case of a willful inspection or disclosure, or an inspection or disclosure which is the result of gross negligence, punitive damages, plus 2. The cost of the actions, plus 3. In the case of a plaintiff, which is described in sections 7430C4A3, reasonable attorney's fees, except that if the defendant is the United States, may he award only if the plaintiff is the prevailing party as determined under section 7430C4. Title 26 Internal Revenue Code, Subtitle F, Procedures and Administration, Chapter 75, Crimes, Other Offenses, and Forfeitures. Subchapter A, Crimes, Part 1, General Provisions. Sections 7213. Unauthorized disclosure of information. A. Returns and return information. 1. Federal employees and other persons. It shall be unlawful for any officer or employee of the United States or any person described in Section 6103N, or an officer or employee of any such person or any former officer or employee willfully to disclose to any person except as authorized in this title any return or return information as defined in Section 6103B. Any violation of this paragraph shall be a felony punishable upon conviction by a fine in any amount not exceeding $5,000 or imprisonment of not more than 5 years, or both, together with the cost of prosecution. And if such offense is committed by any officer or employee of the United States, he shall, in addition to any other punishment, be dismissed from office or discharged from employment upon conviction for such offense. E. Cross reference. 2. Penalties. Penalties for disclosure of confidential information. For penalties for disclosure of confidential information by any officer or employee of the United States or any department or agency thereof, see Title 18 U.S.C. 1905. Title 18, Crimes and Criminal Procedures, Part 1, Crimes, Chapter 93, Public Officers and Employees. Section 1905, disclosure of confidential information generally, however, whoever being an officer or employee of the United States or of any department or agency thereof, any person acting on behalf of the Office of Federal Housing Enterprise Oversight or agent of the Department of Justice, as defined in the Antitrust Civil Process Act. Title 15 U.S.C. 1311 and 1314 publishes, divulges, discloses, or makes known in any manner or to any extent not authorized by law any information coming to him in the course of his employment or official duties, or by reason of any examination or investigation made by, or return, report, or record made to or filed with such department or agency or officer or employee thereof, which information concerns or relates to the trade secrets, processes, operations, style of work, or apparatus, or to the identity, confidential statistical data, amount, or source of any income, profits, losses, or expenditures of any person, firm, partnership, corporation, or association, or permits any income return or copy thereof or any book containing any abstract or particulars thereof to be seen or examined by any person except as provided by law, shall be fined under this title or imprisoned not more than 1 year or both, and shall be removed from office or employment. Anyway, Eddie said that ARL definitely wants to do one of these Section 6301 actions so that they can have experience testing it for themselves. It seems that the judges and the IRS pay attention to this issue, for when have you ever seen the IRS capitulate as they did in the Reedy case? That's because it involves procedural error. In Eddie's experience, procedural error is something that he has always seen judges acknowledge. All right, it's kind of like an ethics violation. And ethics violations will cause people to lose their jobs, as you just heard up above. They could be ignorant of the fact, but they cannot be ignorant of the law, ladies and gentlemen. Ignorance of the law excuses nobody. They can be ignorant of the fact all day long, but ignorance of the law will not be tolerated nor excused. IRS shows bill of exchange payment as bankruptcy discharge. Eddie Kahn, or Kahn, however you say it, also told us this week about another interesting bit of information regarding how the IRS reflects bills of exchange payments in their records. It seems that when a person uses a bill of exchange to pay for an alleged IRS debt, the IRS shows the payment as a discharge through bankruptcy. American Rights Litigators, ARL, became aware of this after reviewing the IRS individual master file, IMF, on one of their clients whom the IRS previously claimed to owe $900. The client became a creditor to his straw man and used a bill of exchange to discharge the alleged $900,000 debt. As such, ARL assumes that this is how and why the IRS zeroed out this client's tax account for the tax year in question. We believe the client whom Eddie referred to may have been the doctor that we wrote about in the 9/10 of '02 edition of Tax Truth newsletter. Eddie found this bankruptcy discharge coding rather interesting. On his personal IRS situation, the IRS was after Eddie not too long ago for the tax years 1986, 1987, and 1988. Therefore, he gave the IRS a bill of exchange for those 3 years to discharge the alleged tax debt. Then, about 3 months later, he got a letter from the IRS acknowledging their receipt of his correspondence. They said they would give him an answer within 60 days. That's a pretty typical response. When you got him by the short and curlies, they'll always ask for that extension of time, and we're always going to give it to him as a matter of grace, equity. 1 month after that, Eddie got a second letter from the IRS saying that they transferred the matter to the IRS office in Jacksonville, Florida. The only information they provided was a phone number. Eddie called the phone number and discovered that it was the IRS Bankruptcy Division. Thus, it appears that the IRS is going to record Eddie's bill of exchange payment as a bankruptcy discharge as well. This lends further credence to the idea that a bankruptcy discharge is how the IRS enters a bill of exchange payment on their books. The IRS doesn't show the account as paid, but rather as canceled out through bankruptcy upon calling the number. Eddie talked to a man there who said that there was a specific woman who he needed to contact. Therefore, Eddie tried calling her several times so he could try to get some answers from her as to how the matter was in bankruptcy. However, he wasn't able to make contact with her, and to date, she has not returned his call. No surprise there. Eddie sues American rights litigator and bank. The last time we wrote about ARL's bankruptcy situation in the February 11th of 02 edition of Tax Truth newsletter, we reported that the judge dismissed the case. Therefore, Eddie filed a lawsuit as a creditor against American Rights Litigators, ARL, and the bank holding ARL's funds. Since that time, the bank responded with a motion to dismiss Eddie's lawsuit. The bank's attorneys based his motion on the presumption that Eddie and ARL are one of the same person as the IRS nominee, Levy, implied last June. However, Eddie is and always has been a separate person from American rights litigators. To make this even more apparent, Eddie resigned from his position as executive trustee and general manager of ARL. He just works there now as a consultant. In his lawsuit against ARL, Eddie claims that he is a secured party and ARL owes him consultant fees. Therefore, the money frozen in ARL's bank account is his. The bank's position, however, is that the Internal Revenue Service is owed the money. Yet, so far, the IRS has not come in as a party to Eddie's lawsuit and submitted a claim. If the IRS doesn't have a secured claim, then it doesn't matter what the bank says. Besides, the bank's petition for a summary judgment from the court to dismiss the case is moot for another reason. There is a controversy. Eddie already discharged the debt that the IRS alleged in their nominee levy against ARL with a bill of exchange. This makes for 2 strikes against the bank, which gives them a very weak position. It will be interesting to see how this all plays out. Eddie said the court scheduled the first hearing on March 7th, 2003. So, what did we gather from this? Your private intellectual property cannot be disseminated by anybody without your express written consent. And by publishing that in the paper or publishing it with the county recorder's office, they are discrediting your reputation. A reputation, ladies and gentlemen, is what is known as a general intangible. It's a right. You have a right to that reputation. You have earned it. You have built it up. You have nurtured it. Your word is your bond. Maybe your reputation isn't that great, but nevertheless, it doesn't excuse them for violating the law, especially when it's in their own IRM manual, ladies and gentlemen. Okay? These are their own rules that are supported by the USC, amongst other factors, including Title 15. So without your express written consent, uh, they do not have the right to disseminate your private intellectual information, including your statements, the alleged debt due and owing, the date of birth, the social security number, your name. None of that belongs on public record in a levy or a lien prior to being adjudicated. All right. And they almost never do it. It's $1,000 per violation. So what they're suggesting here is if you got a town of 4,000 people, that's 4,000 counts at $1,000 a whack. That's a nice payday. And from the sounds of it, you can go to the Attorney General, and the Attorney General will be more than happy to settle that for you. So again, this is also true, ladies and gentlemen, on foreclosures. They plaster your name and everything else, and they put it out there for everybody, and they tarnish your reputation. They make you look like a deadbeat. And look, I'm all about paying those debts. Pay them fucking debts. If you owe a debt, pay that debt. Let me tell you something. The biggest deadbeats are the United States government and trustees. They're the biggest fucking schmucks when it comes to being deadbeat debtors. They never want to pay the debt. They want to squander away shit that they don't have. They want to rob, rape, and pillage from the Social Security. They want to rob, rape, and pillage from future generations that aren't even born yet. All right? So I'm all for debtors paying their debt, ladies and gentlemen. Let's channel that energy in the right direction. I'm also all about protecting the interest of the Treasury. Why? Because I'm a preferred stockholder in the Treasury. I have special drawing rights. So in order to comprehend that, I have done a number of videos on the Bill of Exchange Act and the Negotiable Instruments Act of 1881, amended in 1882 and adopted by the United States, from which the UCC, most of the language in 8 and 9 and 3 came directly from the Act of 1881, amended in 1882, known as the Negotiable Instrument Act, or the I'm having a brain fart this morning. My apologies. The Negotiable Instruments Act, or the Bill of Exchange Act. Okay. And we got the Bill of Exchange Act from Indonesia. Those people over there, they are pencil pushing bean counters, let me tell you. And they're very sharp people. So we just adopted it. Canada adopted it, then we adopted it, and then we got the law of the mother country that allows us to use it. And if you read the Canadian Bill of Exchange Act, ladies and gentlemen, they will talk about consumer transactions. You're not going to see that in the UCC. No. You want to learn how to do a real consumer transaction, you're going to want to read the Negotiable Instruments Act, Bill of Exchange Act of 1882. And in there, at about 190, I believe it's chapter 5, it will really delve deep into how you sign documents, how you express your intent, to ensure that you're engaged in a consumer transaction. All right. And that the negotiable instrument is a consumer transaction. Okay. So with that said, you can go check out the other videos. Thanks again, Mark Metz. Really appreciate you sharing that with us. And I do these videos so you at home can work, take care of your little crotch goblins that are pissing, burping, screaming, and crying, and you can still learn on the fly. So thanks for joining me. Thanks for all your support at selfgovernanceU.com. That's what makes all this possible. And we'll talk to you soon.